Today's webinar is it's on the issue of relevance, facts in terms of relevance, as well as facts and issue, and how facts are treated under the Indian Evidence Act. Getting right into it, see the point at which we start is the Indian Evidence Act, which is in a court of law, two things have to be done. The question is, what should the court listen to? And the second question is, how should the court believe it? So the question becomes, what facts can the court consider? And the second is, how will you prove those facts? Now, for this webinar, we are not concerned with proving facts. The question that we are concerned with is what facts can the court listen to? Now, your first thought will be, why is this relevant? Pun intended. Why is it important to know what facts a court can listen to? Because remember, I'm taking a criminal trial, for example, the best way the prosecution can harass the accused is by bringing in tons of irrelevant information. And the accused will just get overburdened by how much information he has to deal with and will not be able to present his defense. Similarly, what an accused can do is he can bring in tons of irrelevant information just to continuously delay the trial. And if he's delaying the trial, he's staying away from a conviction, which is the goal of any accused who has committed a crime and something the law has to prevent. So for these two reasons, to balance out the interest of an accused who should only have to deal with pertinent information and not random facts, as well as the prosecution who have a vested interest in a trial being focused, speedy, and not allowing the accused to drag it out, the Indian Evidence Act creates something called relevance. Now, there must be the first question that you all must have, because you all have all seen TV shows and maybe read books, etc., is what is relevance? All we've heard about is this evidence is not admissible. Is there a difference between relevance and admissible, or are they the same thing? Is something admissible if it's relevant? Is something relevant if it's admissible? Now, my response to that is they are two very different things. You can't combine relevance with admissibility. Relevance is one criteria based on which information can be rejected or accepted by a court. Admissibility is another. And any piece of evidence and any fact has to be both admissible as well as relevant. Now, this might sound very theoretical to you. So I'll give you a slight example on the difference between relevance and admissible. So does anyone here know what the meaning chain of custody means?
So the chain of custody would mean when any evidence is collected, how does it move from one particular person to the other? So for example, if the police officers who reach a crime scene, they collect a particular, say a knife, for example, then that is given to the investigating officer who is investigating the entire crime. So this is how the chain of custody is established. How it moves, how one particular piece of evidence moves from through different people.
I think Ayushman answered. Yeah, Ayushman, you're absolutely right. Just to sort of expand on what you said, the chain of custody is essentially a way a court makes sure that evidence was not tampered with. So taking Ayushman's example, let's say there is a knife with blood on it found at the crime scene. Now, two things are very important. One is to find out whose blood that is on the knife. And the second is that nobody tampers with the blood on the knife, because otherwise anybody can be falsely implicated in the crime by putting some other person's blood over there, which is what any accused will say. He'll say, that was not my blood. I was never at the crime scene. So for that, the court has to be able to trust that the blood on the knife is sacrosanct from that incident of that day. So the prosecution will have to show that, yes, the police officer reached the spot in front of two independent witnesses. He put the knife inside a sealed cover. This sealed cover was sent by this constable to the forensic lab. It was not opened while that constable took it. It was opened only at the forensic lab, and then it was evaluated. And only then can the blood be trusted. This is the chain of custody. Now, the difference between relevance and admissibility is easily captured by this example, because that nobody over here will doubt that that blood is relevant, right, to finding out who committed the crime, or at least who the victim was. But if, for example, the prosecution fails to show that that knife was sealed, let's say the knife was picked up at the scene of the crime, it was taken to the police station, it was sealed 1 day later, and then it was sent to the lab, the first thing the accused will say is, you know what, the chain of custody has broken. That knife, Nobody knows what happened in that one day where the knife was not sealed. And then the fact becomes that this knife may not be admissible as evidence, or it may not even be reliable evidence if admitted. But that blood, the fact that there was blood on the knife will always be a relevant fact. So are you understanding the distinction? There are certain rules by which the Evidence Act excludes certain things on admissibility grounds. Now, the most famous example I can give you for this is regarding electronic evidence. Now, I'm sure you all haven't studied it, but under section 65B, or I hope you all have studied it, it's quite critical. Under section 65B of the Indian Evidence Act, the Supreme Court has emphatically held that no electronic document, that is no CD, no video footage, nothing that is electronic in nature is admissible without an 65B certificate, which is essentially a certificate saying I recorded this properly, this was recorded in the correct atmosphere, I have not tampered with it while recording it. Now I'll give you an example involving a 65B certificate. Let's say there is a camera in a room where a murder took place, and that camera has video recorded the entire incident taking place. There's no dispute that this video footage is relevant because it's recorded the actual incident taking place. There will be several sections from 6 to 15 which will cover it. But if there is no 65B certificate along with it, then even though it is relevant, it is not admissible. The point I'm trying to make here is the Indian Evidence Act creates two restrictions on facts being considered by a court. First, you have to prove that they are relevant. Then you have to prove they are admissible. If any of these are not done, then the court will not be able to consider that fact. Now, where do I get this from? See, as lawyers, we can't talk in the air. I can't tell you things and expect you to believe them. I hope all of you all have a copy of the Indian Evidence Act in front of you. Even if you don't, I will be reading out the sections because, well, I know how students are. I didn't carry my bear to class quite often. So let's go right to it. Relevant. This is in the definition section of the Indian Evidence Act. A fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act. So relevance is not an abstract concept. It's not, I will say it is relevant and someone else will say it is irrelevant. No, the Indian Evidence Act specifically defines what constitutes relevance in section 6 to 15. The other aspect that has to be considered is facts in issue. It's the next definition. The expression facts in issue means and includes any fact from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceedings necessarily follows. So that means there are two kinds of facts that seem to exist. One are facts in issue and the other are relevant facts. And section 5 of the Indian Evidence Act states that evidence may be given in any suit or proceeding only on the existence or non-existence of every fact in issue and such other facts that are decided to be relevant facts and no others. So only facts which are either facts in issue or relevant facts can be proved in evidence. Nothing else can be proved in evidence. You understand the funnels that are being created by the Indian Evidence Act. A trial is taking place. If I want to tell the court anything, it has to either be a relevant fact or a fact in issue. Now, one question that may arise in your minds is what is the difference between a relevant fact or a fact in issue? So I'm just going to touch upon the different kinds of relevant facts that exist under the Indian Evidence Act. So let's say I'm not going to go through all of them because they're extremely difficult to understand. I mean, extremely vast, really. So let's look at section 8, motive, preparation, and previous or subsequent conduct. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. So a fact in issue in a murder trial, let's say the allegation is that Aditya murdered Yashank. Okay. A fact in issue will be, did Aditya murder Yashank? A fact in issue will be, did Aditya have the mental intention to kill Yashank? Because these are the two critical things that have to be proved in the trial. Okay. Without these two being proved, Aditya Mehta cannot be convicted of murder. You have to prove that Aditya Mehta stabbed Yashank, and you have to prove that Aditya Mehta intended to stab Yashank. It's not that Aditya Mehta was walking with a knife, slipped, fell down, and unfortunately, while he was trying to break his fall, Yashank was lying there, sleeping. So these are the two critical facts. But tomorrow, if the prosecution goes to a court of law and tells them Aditya Mehta stabbed Yashank because he wanted to stab Yashank, how can you prove Aditya Mehta wanted to stab Yashank? And there comes in section 8, which says any fact which is relevant, which shows or constitutes a motive or preparation. So what the prosecution is then allowed to do, because my motive has become relevant, is it can bring evidence with respect to any previous enmity I have with Yashank. It can bring in evidence with respect to maybe Yashank and I have a property dispute. Maybe Yashank used to have an affair with my wife. These become relevant towards a murder trial. My point being, facts in issue are the critical facts, the facts which make up the essence of a trial. But no trial is only did Aditya murder Yashank, did Aditya intend to murder Yashank, or murder is an extreme example. We look at a simpler example, we say something like robbery. Did Aditya enter the house with the intention to commit the crime? Did Aditya take the money? Did Aditya leave without making due payment for whatever he stole? These are the facts in issue. But it's never going to be easy to prove just these bare facts, especially intention. And that's why you need surrounding relevant facts which are defined in the Indian Evidence Act. And thus, with facts in issue and relevant facts, together we have the network that constitutes the Indian Evidence Act. Just to sort of recap where we were, and then I think I'll do a bit of an exercise. The Indian Evidence Act, as per Section 5, only allows you to produce evidence for relevant facts and for facts in issue. Facts in issue are those bare facts which, if proved, will convict a person or hold a person liable in civil law, and if disproved, will mean a person is acquitted or a person cannot be held in liable. But these facts themselves are not enough in a criminal trial, and therefore certain other relevant facts are also allowed to be brought in, such as motive, such as preparation. Do not, however, confuse relevance with admissibility. Relevance and facts in issue are the facts to which evidence can be produced in a court of law. Once a fact is relevant, does not mean it is admissible. In this example, remember the chain of custody point. Once the chain of custody has been broken, that blood on a gun, if that blood has been tampered with, even though that blood is relevant, even though that blood may even be a fact in issue, it's not admissible because the chain of custody is broken. Similarly, even if I take a video of the crime taking place, of a murder taking place, of a robbery taking place, or a video of any other civil dispute, of a wife being cruel to her husband, I cannot produce that in court unless I produce a 65B certificate, as per Section 65B of the Indian Evidence Act. Now, the question that has been asked by Shreyasi Srivastava is, what is the difference between motive and intention? Now, I'm going to give you a twofold answer to this. One is going to be the easy to understand answer, and one is going to be the hyper technical answer as per the Indian Evidence Act. So the easy to understand answer is motive and intention are two completely different things. Let's say Yashank was having an affair with my wife. My motive is that I'm angry that Yashank is having an affair with my wife. I want to extract revenge on Yashank having an affair with my wife. But my intention is respect to what I do to Yashank. So I can either punch Yashank, and then my intention is only to punch Yashank. Yeah, I can stab Yashank, and then my intention is only to stab Yashank to death. Let's say I punch Yashank and I punch him. Unfortunately, when he falls down from my punch, he falls on a very, very sharp nail that some construction worker had left on the road. And that nail goes through his body and then he dies. Then it's very important to remember that my motive was only to punch Yashank. My intention was not to kill Yashank. My intention was only to punch Yashank. You understand the difference? Motive is why you commit a crime. Intention is what you wanted to commit in the crime. That's the way to understand it. So moving beyond Yashank and his affair with my non-existent wife, let's say you and I have a bitter dispute over property. And because we've had this property dispute, I decide to forge an agreement in which your because of which you lose your inheritance. Now, my intention is only to commit forgery. My motivation is to take revenge for our other fight. I hope this is clear. All right. Next question by Sanjay. Within the context of facts in issue and relevant facts, where would factum probandum and factum probans be placed? See, you're misunderstanding the crux of what I'm getting at. See, factum probandum basically means a whole, I mean, a fact offered in evidence as proof of another fact, to use the technical definition. Now, that is not it. The question is whether that fact is relevant in itself. Its relevance has to be established independently of where it comes in. So to think of a slightly off the cuff example, if I am trying to prove that someone is in the room, in order to prove that he has committed a murder, you have to prove that someone being in the room is relevant in itself. I hope that explains what you're looking at, what answers your doubt, Sanjay. It's that each fact that you're trying to prove, even if it's trying to lead to another fact being proved by virtue of it, both of them have to be shown to be relevant. So while explaining relevance in the affair and murder example, you said that there must be a network. I was wondering what exactly that meant. Oh, by network, I think I misspoke. I meant that it's very difficult to in a case, in a trial, it's usually very difficult to prove the bare facts, that is Aditya let's take an example of, say, the any I don't know if y'all have heard of, I'm just going to use popular examples so that it keeps the interest going. Y'all have heard of the Shakti Mills rape incident, right? So there was a rape that took place in Shakti Mills where there were 5 men, more than 5 men, who allegedly raped this woman who was walking around in Shakti Mills. Now, the difficulty is that when that woman comes out of her rape incident, she will testify that this rape took place and they have committed this crime against me. And 5 of them will testify that this rape did not take place, this woman is lying. Now, that is the nature of, say, rape as an offense. It's men generally are problematic in that they commit it in isolated areas where they won't be seen. And if there are multiple accused, then they will say, look, 4 of us are saying it didn't happen, that one lady is saying it happened, how can you believe her? So often what the prosecution has to do is, they will, of course, the victim's testimony has to be relied on, and the several judgments have said that the victim's testimony can be the sole basis if it is of a sterling quality. But the prosecution will introduce other surrounding facts to show that this crime took place, which is that they will show CCTV footage which put those men in the area at the time. They will bring in the clothes of the woman. Now, the clothes of the woman are not relevant to show that a rape took place, are they not? The question of rape is whether there was an incident of sexual assault. But clothes become relevant under the Indian Evidence Act if there is, say, blood on them, if they are torn, because the woman will say that I struggled and while I was struggling, my clothes tore. Or the men's clothes will be taken. If the woman's blood is on the men's clothes, if the woman's sweat is on the men's clothes. So these are all not directly connected with the allegation of rape, but they are relevant. And that's what I meant perhaps by a network of facts, which is that to prove any crime or even any civil dispute, in a contractual dispute between you and I, if I have to prove that this is what let's say I enter into a contract to buy 50 fish from you. Okay. And what you instead try to do is I obviously meant that I wanted to buy 50 high quality fish, but you try to sell me 50 low quality fish. Then I will have to show 7 or 8 facts that will surround the contractual debate, negotiation, and discussion to prove that no, I meant high quality fish. That's what I must have meant by a network of facts. And that's why relevance becomes important, because in a trial, it'll never be, did Aditya murder Yashank and did Aditya intend to murder Yashank? The questions that will be on the judge's mind are, was Aditya at the scene of crime? Why did Aditya kill Yashank? Did Yashank try to defend himself? And that's how relevance comes in. The next question by Shalini is, how can we prove someone's intention, either if it is in good faith or in bad faith? That's why the circumstances become relevant, no? That's how you prove it. It's that, okay, fine. If the evidence against me is that some witness saw me punching Yashank on his face, and then Yashank died of a nail that has gone through his stomach, obviously it's clear that it's not my fault that the nail went through his stomach. My intention may have been bad in that I wanted to punch him, but my intention was not so bad insofar as I intended to murder him. I hope that answers your question. How you prove someone's intention is always difficult. It's always based on circumstances. It's never going to be direct. Are there any more questions on this framework outline I've given you on the Indian Evidence Act? Because that's the starting point for evidence, and this is something that it's a hyper technical reality. Sometimes in day-to-day practice in courts, we forget these things exist, that there is a different thing like relevance, there is a different thing like a fact and issue, there is a different thing like a admissibility question. You just lump it all together and you go about it. But if you do that, you'll never really understand the beauty of the Indian Evidence Act. Now, I think what I've tried to tell you so far is how the courts treat evidence and how the Indian Evidence Act makes some facts relevant so that you can prove your case. But I'm going to go a little deeper now. Okay. The question becomes, now, if you see section 6 to section 15 of the Indian Evidence Act, and I'm just going to quickly touch upon them so that you get an idea of what's going on. Facts which are the occasion. So cause and effects can be proved as per the Indian Evidence Act, they are relevant. Or facts that are necessary to introduce or explain relevant facts or facts in issue. So for example, let's say they want to prove that I murdered Yashank. But the first question that the accused will ask is, how can you prove I murdered him? I was not even there. Because the murder allegedly took place in Yashank's house. I never go to Yashank's house. I always stay in my own house after I come back from office. So what the prosecution will then have to do is it will have to show evidence of CCTV footage which shows my car from some traffic CCTV footage that caught me driving towards Yashank's house. They may have a neighbor around Yashank's house who saw me roaming around in his street. So this is not directly relevant to the fact and issue, but it introduces the fact that I was at Yashank's house, right? Then you need to introduce Yashank a little bit. Who is Yashank? How does Yashank know my wife? This is all connected to my motive. But unless this is put into perspective, nobody will trust that Aditya Mehta, who seems like a very reasonable guy, practices as an advocate, is a law-abiding citizen, studied hard throughout his college, went to a good college, and now is in fact teaching at Plea, went and murdered Yashank. It's difficult to believe. So for the prosecution to build a watertight case, they will have to introduce the relationship my wife had with Yashank, introduce who Yashank is, how my wife got to know him. And therefore, they will be able to prove, because there may be no direct eyewitness who saw Aditya Mehta stabbing Yashank. Aditya Mehta is a shrewd criminal. But if they place these introductory facts into the picture, then it becomes believable that Aditya did in fact murder Yashank. Now, one thing where this relevance, when facts not otherwise relevant become relevant, is the other thing I want to bring up, is that sometimes some facts are not relevant, generally speaking. But if they are inconsistent with a fact and evidence, then they become relevant. So let's look at the example over here. Whether Aditya Mehta can drive or not is not relevant to a murder trial in general. But if the prosecution's case is that Aditya Mehta drove to Yashank's house, we have CCTV footage putting Aditya in the driver's seat near Yashank's house, then I am allowed to introduce evidence that Aditya Mehta doesn't know how to drive, he doesn't have a valid driving license, he doesn't even own a car. Do you understand the beauty of the Indian Evidence Act here? It is that it foresaw that sometimes the prosecution will put up a bogus case and it will introduce facts that that aren't directly relevant. But I may need to bring these facts to oppose the prosecution, which is the easiest example was I don't drive. Now, if someone comes and tells me, Aditya Mehta, you are being tried for the murder of Yashank, do you think your ability to drive is relevant or not? My first thought will be no. The question is whether I stabbed Yashank, whether I was there where Yashank was, whether I even know who Yashank is. But suddenly the fact that I don't drive becomes relevant because it shows that the prosecution case is completely contradictory, because the prosecution case alleges that I am in the driver's seat driving to Yashank's house. So that is something the Indian Evidence Act has been particularly shrewd about, in that they let you bring in facts that would seem distantly irrelevant to come to the fore. Now, remember one thing, and it's important to recognize this. Just because a fact is relevant as per the Indian Evidence Act, and I can put evidence to prove it, doesn't mean the court has to rely on it. So the other complication that comes in is whether evidence is reliable or not. So what will smart defense lawyer Aditya do for himself? He will prove that Aditya Mehta does not own a car. One. He will prove that Aditya Mehta does not own a driving license. 2. Number 3, that Aditya Mehta does not drive to office every day. He takes a cab, he takes the train, or he takes a bus, or he takes an Uber. Whatever Aditya Mehta takes, Aditya Mehta will prove he doesn't drive, therefore the prosecution case is faulty. This is a relevant fact. But the court can choose not to rely on this fact because the court is also smart. The court will say, look, the fact is the prosecution puts you in a driver's seat. In a car moving to Yashank's house, that camera doesn't capture you in the driver's seat. You could have hired a driver that day. You could have asked a friend to drive you, who's actually your accomplice. So relevance is only an entry barrier. Once I have proved my fact is relevant, I can put the evidence in court that, look, Aditya Mehta doesn't have a driving license, he never drives. But the court is not constrained to say, oh, this evidence has come, it is relevant, I have to rely on it. A judge has the discretion eventually to decide which facts to rely on and which facts to not rely on. So you see how it gets slowly more and more complicated with the Indian Evidence Act. First rule, only evidence that is relevant or a fact and issue can be brought into the court. Once it is brought into the court, it has to be proved to be admissible as per other rules that the Indian Evidence Act brings in. And finally, even if it is relevant and admissible, the court doesn't have to rely on it. The court can decide not to rely on it. The last thing I want to do is the Indian Evidence Act does something quite novel, in my opinion. And it's actually good lawmaking, which is the Indian Evidence Act decides that some facts are not relevant. Now, why does the Indian Evidence Act do this? It's because sometimes people have a tendency of relying on things that should not be relied upon. What do I mean by that? If for those of you all who have the Indian Evidence Act in front of you, why don't you go to section 53A? Section 53A was brought in by an amendment. It was brought in by a 2018 amendment, and an amendment before that was there as well, which says, in a prosecution for an offense of, essentially, I'm not going to read it out because it's a little detailed, in a case for rape or molestation, or for an attempt to commit any such offense, where the question is of whether the woman consented or not, evidence of the character of the victim or such person's previous sexual experience with any other person shall not be relevant on the issue of consent or quality of consent. Can anyone tell me why this section was brought into the Indian Evidence Act by amendment? I think it's something we should all think about. And it's not difficult to figure out. You don't have to have pre-existing knowledge. There is a section which states that previous consent of a woman in a rape trial or her previous sexual experience is not relevant. Why?
Sir, I think the answer is that the defense counsel in a lot of trials for the accused, they used to take up this defense or they used to bring this argument that this woman is promiscuous in nature. She has had a lot of sexual encounters in the past, and she is very she's very open-minded towards casual sex and all. So therefore, we can assume that it was not a forced sexual intercourse when she had actually consented to it. And also there's a lot of character assassination that she drinks and go out in the night, and all of that is attached to this thing.
Absolutely. I think Ayushman has done a great job in stating it. I will just capture what he said. It's very straightforward. It's that in India, because of the patriarchal mindset of lawyers, of people, and sadly of judges also, how you defend, a lot of the times the defense in a rape trial is that it wasn't rape, it was actually consensual. And how people used to prove this is they used to state that, no, this woman has had intercourse with multiple people before this. Or this woman is, as Ayushman put it, promiscuous. Shivankar, sorry, has brought in a good point, which is when this amendment was brought in. But the idea is it should not be allowed that just because a woman has had any sexual history, whether she has had sex with multiple partners, one partner, several partners, it's not relevant, because even if I have had sex with 50 people, my 51st incident could be a case of rape. Those 50 cases before that are irrelevant. But because men and judges have a patriarchal mindset which says that, oh, a woman who has sex cannot be trusted, they used to consider this a relevant fact. And people used to bring this in as a relevant fact because, as I read out earlier, you're allowed to introduce parties, you're allowed to introduce relevant facts, no? So accused used to say this is relevant under section so and so because it introduces the girl, it introduces the victim, it's pertinent to the circumstances. So Parliament created Section 53A, which says this is not relevant. Now, even if I think it's relevant under any other section of the Indian Evidence Act, Section 53A will specifically exclude it. And it takes away my ability to prove these facts. In fact, even if I try to bring this fact into court, the judge will tell me, I'm sorry, I'm not allowed to hear this. This evidence is not relevant. It cannot be brought into this court. Now, let's move forward. Another good example of this, which is slightly different, is previous bad character not relevant except in reply. Section 54, it states that in criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character. Now, my point over here is that people, how do we make judgments on our day-to-day life? How do we don't look at people's criminal records with our friends and family or with our acquaintances, colleagues, batchmates in college, whatever. We just think about, oh, that guy has cheated on a test previously, he will cheat on this test also. Or that guy has been rude to someone earlier, he's likely to have been rude in a given situation. And because of this mindset, bad character becomes a basis on which we often decide people are responsible whether they've done it or not. To use a slightly dicey example, it's that Kangana Ranaut is known to make inflammatory statements on social media platforms, right? And therefore, when Kangana Ranaut says something without necessarily looking at her intent, people will decide she was being inflammatory. I'm not defending her latest statement, by the way, on the basis of which Twitter has banned her. I think that was quite inflammatory. But I'm saying that people have a reputation. And when people have a reputation, people use that bad character to state that इसने ये गलत किया ही होगा. Which is why when tomorrow Javed Akhtar finds a defamation case against Kangana Ranaut, Javed Akhtar's lawyer may be tempted to argue that, look at Kangana Ranaut, she has said so many defamatory things, so many inflammatory things, she must have said this one also. But that's not allowed, because the law recognizes that humans have a tendency to go based on reputation. Humans have a tendency to be judgmental. But that is not correct, because in a criminal trial, someone is going to jail. And if someone is going to jail, it doesn't matter if they were doing 20 wrong things before that. Their character is not relevant unless, of course, they've decided to make it relevant. You have to prove the facts and the offense independently, which is why it's explicitly stated that in criminal proceedings, the fact that the accused person has a bad character is irrelevant. Look at the condition though. Unless evidence has been given that he has a good character. So now if Kangana Ranaut decides to produce evidence of her Padma Shri saying she is a great person, she's received this award, she's received that recognition, then she's made it about her character. Then Javed Akhtar can bring in her bad character. You understand what relevance is doing here? Relevance is basically, relevance under the Indian Evidence Act is envisaged to be a filter. Because if anything and everything was allowed to be said in courts, I assure you, lawyers love the sound of their own voice. Lawyers love the sound of their own voice. Lawyers earn money every time they go to court. Well, some of them. So they would keep going to court and they would drag proceedings on and on. The other thing you have to realize is, in any case that in an adversarial system like ours, in any case, there is a winner and a loser. Either a person is convicted or he is acquitted. Either a person has to pay damages or he doesn't have to pay anything. Now, in such a system, one party always has an interest to delay, to confuse, to make things complicated, unnecessarily complicated. And that is where relevance becomes critical, because unless you can show that what you are saying is relevant under any section under the Indian Evidence Act, what you are saying will not be considered by the court. And taking a step further, what has been done is certain things have been deemed to be irrelevant. They cannot be considered by the court unless you can show why it should be relevant. Say, suppose your opposing side chooses to bring some evidence which may not be admissible. Be careful. She's used admissible. Did she mean admissible or relevant? That's what I'm saying. You have to be very careful with your words. In trial, putting it in a crude way, should one be directly jump off their seat to object that it is not admissible? As if it is oral evidence affecting a person's character, it may not be admitted, but it would naturally have some impact on a judge's mind about the witness. Absolutely right. It's as simple as this. You have to object right away because you're right that it will have some impact on a judge's mind whether it's admissible or not. Because the fact is, tomorrow, let's say a man is on trial for the rape of a lady. this guy will bring up evidence of her previous sexual experience, and if the prosecution if the what do you call prosecution does not object, a patriarchal judge will be influenced by it. Even if on paper he doesn't record that evidence and he casually tells that lawyer of the accused that you're behaving in a problematic fashion, but the fact is he might be prejudiced. So you have to be proactive in a trial. You have to stand up and object. And if the judge is not taking you seriously, you tell him to he's not recording your objection. And further, there have in fact there is a who's that journalist in Telka, the Tehelka journalist who's facing a trial for sexual harassment. In fact, what was happening here, I can't remember his name. I'll just remember it in a minute and I'll tell you all. His trial was taking place in Goa, and during his trial, Tarun Tejpal, yes, he's accused of raping a journalist colleague. His trial was taking place in Goa, and the lawyers for the victim actually moved a writ petition in the Bombay High Court Goa bench, saying that look, that woman's evidence is being recorded and his lawyers are being unnecessarily aggressive. They're asking irrelevant questions that are going on and the trial judge is not stopping them. And they filed this writ petition and they put pressure on that trial judge, because then that trial judge realizes, okay, this is problematic. The High Court is looking at me. This entire trial is being produced in the newspapers. I should take these objections more seriously. So you're absolutely right. You have to be aggressive, because if you are not aggressive, then if it was going to influence the judge, it will influence the judge, even if it's not recorded on paper. But in rape cases, mostly victims go through uncomfortable questions. What about that, sir? Agam very nicely and sweetly has put in the name Tarun Tejpal. In rape cases, mostly the victims go through uncomfortable questions. What about that? Now, see, there's a difference between uncomfortable and problematic. This is a little difficult to navigate, but let me put it this way. If a woman is saying that a man raped her, it's terrible. It's a terrible thing. It's terrible for the woman to have to say it, because she also goes through stigma. It's terrible, much more terrible that a man ever did something so reprehensible. But the fact is, the outcome of that woman's statement may be that a man goes to jail for 7 years or 10 years or maybe even the rest of his life. And if such stark consequences of a person's liberty being taken away for 10 years or 15 years flow from a woman's statements, then the accused should have a right to ask uncomfortable questions so that the truth comes out. But there have to be limits. There have to be limits of decency. You're not allowed to ask questions that violate the decency or the respect that a woman is allowed to have about her privacy. And of course, they have to be excluding certain obviously irrelevant aspects, like her previous sexual experiences, like whether she has a boyfriend, like whether she has a husband, like whether she's had an affair also. It's not relevant because that's not connected. So it's a fine line that defense lawyers have to tread. They have to ask uncomfortable questions. That's their obligation to their client, and that's something the law allows for, because sometimes uncomfortable doesn't necessarily have to be a bad thing, and it's necessary to get to the truth. But what the law does draw a line on is irrelevance. And what has been deemed to be irrelevant is a woman's previous sexual experience. So I hope that answers your question, because there's no straight answer. It's about finding that balance. Now, Arya Jain has asked, what are the parameters for defining bad character? Well, that's a very interesting question. I actually was in a trial where a chartered accountant was accused of committing a fraud, a forgery actually. They alleged that he had forged a will. And so we produced evidence of his good character, in that he was the chartered accountant of an ex-attorney Attorney General of India, and that he's been a chartered accountant for 40 years with a wide client base, and he's proved to be very reliable, etc. So that's how we went about proving his good character. And then bad character became relevant, and bad character then could be anything and everything, because they have to contradict our good character case. So the prosecution actually tried to ask questions in cross-examination to these witnesses. Do you know if he has faced any misconduct charges from the Chartered Accountant Institute? Do you know if he has been unprofessional in any particular instance? So there are no parameters per se for bad character. It's extremely broad. The only thing is you have to draw a link to the offense that is taking place. So if someone is being charged of embezzling, that is criminal breach of trust, misappropriating money, then you can bring in bad characters such as how they have embezzled before, how they've lost a job for embezzling, how perhaps they've shown some. You can't bring in bad character evidence like he's been cruel to his wife. They're apples and oranges. But on the other hand, if you're dealing with a trial where a man has allegedly, molested a woman, his previous experience of him being cruel to his wife may be relevant. If she said that he's made her uncomfortable in their family law dispute, for instance. So there's no universal rule that can be put on what are the parameters for bad character. It has to be judged on a case-to-case basis. The test would be if you can draw some causal link between the aspects of his character that you are bringing to light for the court and how that's connected to the allegation against that individual. Moving on then to the final part of this class, which I think is the most fun for me at least, is I'm going to give you a factual situation and I want you to tell me whether the evidence was relevant, admissible, and then reliable. Okay, I'm going to move away from criminal law, by the way, for this, because I think that those are the easier examples. So there is a man has allegedly abused his wife, said some very, very rude things to her, and based on this, she has filed a divorce case against him. Now, during the divorce case, the wife wants to bring in evidence of the husband wants to bring in evidence of the bad relationship between the wife and his mother, that is her mother-in-law. Now, he says that because of this bad relationship, she had said some bad things to my mother, and therefore I said some abusive things to her, becoming angry. Okay. Now, the question is this a fact and issue? Question number 2, is this relevant? Now, how the husband decides to bring in this evidence is he decides to narrate that his mother-in-law, that his father-in-law, that his wife's father-in-law told him that, bahu ne saas se ye kya kaha tha. This is the factual matrix. Now, this is a little outside the scope of just this lecture, but I want you to answer: 1, is this a fact and issue? 2, is this relevant? And 3, is this admissible? Okay, I'll repeat the example once, and I don't think we'll have time for another looking at how slowly this is going. But a man and a wife are having a domestic dispute where the wife alleges that the husband abused her and was unreasonably cruel to her. He used to abuse her for no reason. The husband, as a defense, wants to bring in evidence that the wife has said some terrible things to his mother, that is her mother-in-law, and therefore, and how he seeks to prove this is through his father, that is her father-in-law, told him that this happened. Question R, is this a fact and issue? Question number 2, is this relevant? And 3, is it admissible? I think we've got some answers. Amit Kumar says, yes, it's a fact and issue. Shreyasi says, it's a fact and issue. It is relevant, but it's not admissible because it is hearsay. Those are 2 interesting answers. Does anyone have anything else? Sanjay said it may or may not be relevant. Sanjay, judges aren't allowed to say may or may not. They got to decide. Okay.
I think this is a fact and issue. Okay. I think this is also a relevant fact. Now, admissibility, yes, it is hearsay too, because it comes by way of the father saying this to the son. However, given that this is a family issue, and the fact that the woman has complained that, it is the husband has been cruel because he's been rude to her, I'm not entirely sure, but I think it could be admissible.
Oh, okay, fine. I think that's a good answer. That's almost on point, but everyone's almost on point, but no one's quite there.
I think it is relevant because it is a fact and issue that husband is saying that they had a bad relation and all. The wife used to say bad things to her mother, and the mother herself said that bahu ne aisa kaha. So that thing proves that fact and issue, or that thing is proved by the that statement given by her sass. Like, I think it is supporting that, so it is relevant.
Okay, thank you. Fine. So I think we've got a good bunch of opinions here. If you'll read through the chat, you all will get Chaitali and Dhwani's opinion as well. Now, I'm going to go through this step by step. The first question is, what did I say that the trial was? The trial was the wife has alleged cruelty by her husband. Okay. Now, I may have assumed you all would know what this would mean. Is essentially in a family law trial, you will allege cruelty and based on that seek a divorce. Now, whether the wife was abusive to the mother is not a fact and issue. The only facts and issue would be what all the husband said to the wife and whether that was cruel or not, and whether he intended to be cruel or not. Now, however, the wife's allegation is that my husband said abused me for no reason. But the husband is proving that the wife told the mother certain things which were very, very rude and was rude to her. And that's why the husband was forced to, got angry and insulted his wife or said something to his wife. That is relevant because it's the husband's motive. It explains the circumstances. It explains why the husband got charged up. See, I'll tell you what. Think of it logically. Sometimes in any relationship, rude things may be said. Now, it is cruelty if you are constantly unreasonably rude to someone. But if in one heated fight, you accidentally said one thing that was perhaps a little passive aggressive, a little even aggressive, I'll go as far as saying, because you have heard that your wife has said something to your mother, that may not constitute cruelty. So the husband is not, it's not relevant whether the wife was even spitting on the mother-in-law, because the question before the court is whether the husband is cruel to the wife. So it is not a fact and issue. It is relevant because it will show the motivation of the husband to, maybe he was trying to extract revenge for his mother on his wife, or that's not a good reason. But a good reason would be it will show that the circumstances were charged up. The husband lost his temper. He said something he regrets. So it's not a fact and issue, but it is relevant to the fact and issue, which is whether the husband is cruel to his wife. So the answer is no, it is not a fact and issue, but yes, it is relevant. With respect to admissibility, the son did not hear this from the mother. The son heard this from the father. Now, then it becomes hearsay because the father has to be examined in court and the father has to say, yes, I saw my bahu say this to my saas, or I saw my daughter-in-law say this to my son, my wife. Then it's direct evidence. If the son says the father told him that this took place, then it is hearsay. And then it is inadmissible. Now, obviously, I don't expect you all to get that part right because I haven't taught hearsay in this class and I don't know how many of you all would have studied it. But you understand the difference between a fact and issue and a relevant fact by that example. Every single one of you thought it was a fact and issue because you are straight up saying, oh, this is an explanation for why he may have said it and it shows their domestic dispute background, this, that. But the dispute is not with the mother-in-law. The allegation is not that the mother-in-law is cruel to her. The allegation is my son is unreasonably cruel to me. And the son is explaining one instance of where she alleges he said something by showing that the atmosphere was charged up. Whether that was right or wrong is something the judge will decide. Whether it's a valid explanation is also something the judge will decide. But it is relevant that this domestic dispute was taking place, but it's not a fact.
This example which was given, it with your explanation, and in fact the question which was given, I was confused in itself. Maybe it's my lack of understanding and I want to further understand it better. When there's a divorce trial as such and the ground is of the cruelty which was given, so here when the husband said that there was some motive with him because of which he was charged up and that's why the cruelty happened. The trial is basically for what? Are we understanding that the cruelty happened or not? Or it is to actually get to a point where the divorce is to be decided, wherein maybe this...
So, yeah, I understand your question. See, there are two things that go into a family law trial. One is whether the incident happened. Okay, so whether this incident happened where the husband said something to his wife, and the second is whether it constitutes cruelty. So there are a lot of judgments which say that bickering on a day-to-day basis in marriages takes place regularly. So over here, what the husband was trying to do is that, okay, let's say the wife has proved that the husband told her, you are rude to my family, let's say the allegation is that the wife has said that my husband for no reason tells me that, I am rude to his family, I don't treat his family well, I have no respect for his family, this is cruelty. Now, if the husband manages to show that the reason he said this was because he believed that there was a fight going on where the wife had actually told his mother, that is her mother-in-law, some rude things like whatever may have happened, some domestic dispute. It may have been things like you don't give me my freedom in the house, or you don't respect me, you don't give me my rights. That's why the husband got a little angered and that's why he said these things. Then there is an explanation. Then even if you have to understand that proving an incident doesn't prove cruelty, right? So over here, the husband is then not disputing that he told the wife, yes, you are disrespecting my family. He is saying, I said this because I heard this rumor from my father. I believed it. I got a little nervous. I got a little frazzled. I said these things, but is it really cruel to tell your wife to in all this in a domestic dispute? So you understand, the way to evaluate a fact and issue versus a relevant fact is very simple. It's to see if the answer is yes, is the matter decided? Okay. In this case, even if the answer is yes, the wife said some rude things to her mother-in-law, does that prove that cruelty took place? No. Does that prove that cruelty did not take place? No, because what ultimately cruelty depends on is what the husband said. This is only relevant to properly understand what the husband said, right? That's why it's a relevant fact and not a fact and issue directly. Whereas the fact and issue directly will be, what did the husband say? Now, if the husband has used some very, very bad words, something highly aggressive, if he's called her names like, obviously I can't say them on a call, especially with college students, but if he's used some very, very provocative names, then that is a fact and issue. What did the husband say? Why he said it is a relevant fact. It can allow the court to evaluate it. But the fact and issue is, what did he say and whether that constitutes cruelty. What the wife said to the mother may be relevant to evaluate what the husband said, but it's not directly the fact and issue. Does that help?
Yeah. A little more clear. Thank you.
I have two questions. Can we say reliability includes both relevancy and admissibility? And second question is, if reliability is about court's discretion, so it isn't prejudice to litigants and they have to move to the appellate court if the previous court, inferior court, takes any wrong decision.
Yeah, so to deal with both of them in the order that they were asked, see, reliability is not a mix of relevance. It's not related to relevance or admissibility in any way. Once a fact is relevant and it is admissible, then the court decides whether it is reliable. So, for example, if I punched Yash and Yash comes to the court and he gives a statement saying that Aditya punched me, that is definitely relevant and it is definitely reliable. That it's definitely admissible. But then the court will decide whether Yash is a reliable guy or not. Whether there may be other contradictions in his statements. I may have proved some plane tickets that showed he was actually in Delhi at the time. So first comes relevance and admissibility, and only when a fact is relevant and it's admissible will the court have to decide whether it is reliable. A prime example of this is that a witness comes to court and says that, I saw Aditya punching Yash. But there is CCTV footage that shows that witness was actually in Chennai at the time and not in Bombay where the incident took place. Then the evidence is admissible and it is reliable, but admissible and it is relevant, but it is not reliable. Now, dealing with your second question, which is that the question of giving discretion to judges creates some sort of prejudice to litigants and they may have to move appellate costs. So you're absolutely right. But the fact is the law by its nature is subjective. You can't have a one-size-fits-all methodology ever. So the law will always give some space to judges to use their flexibility, and it hopes that the training that the judges receive, that the judges are competent to use their discretion well. And if not, there's always the appellate court.
It leads to pending lots of pending cases.
Yeah, that's unfortunate. But the issue is, if you don't give judges discretion, then you have a too rigid a system which doesn't allow for flexibility and evolving with the circumstances, because the law can never. So there are 10 million things that can happen, and there are approximately 490 sections in the Criminal Procedure Code, or 150, 680 sections in the Indian Evidence Act. Now, the 180 sections cannot possibly capture the 10 million things that can take place in a courtroom, which is why you have to give judges discretion to interpret, to decide, to use their flexibility.
Aditya, thank you so much